Oh,
So, Mr. Trowell, let's see. It appears that we will be starting with you. Mr. Caldevilla will go into his argument, including part of his presentation on the cross appeal. You'll have your 4 minutes to respond to his arguments, to your arguments, plus, I guess, both sides on the cross appeal and direct appeal. And then we'll go back to Mr. Caldevilla for what we'll say is the swan song, that we will end on that note and consider the matter, what is it, a wrap? Is that what they use in certain professions? But I don't want to shortchange anybody. Have I got it right?
yes, Your Honor.
Okay. Yeah. Then with that said, I have the 4 minute reserve for both counsel, and Mr. Trowell, the floor, as they say, is yours, sir.
Thank you, Your Honor. May it please the court. My name is Lindsey Trowell, and I represent the appellant Geico in this third appeal of this case. I start with a couple quotes. All right, I feel like there's sufficient evidence that the jury is the trier of fact, should tell us whether it's proven or not. All these things that you are arguing to me, you can certainly argue to the jury. Let's see what the jury does, and we'll go from there. Further, I feel like all these things that you're arguing to the court regarding the evidence presented in trial can certainly be argued to the jury. I believe both sides have presented sufficient evidence to let the trier of fact decide their position on the case. I feel all motions for directed verdict should be denied, and the jury should decide this matter. Those are direct quotes from the trial judge in this case, cited at records 7061 and 7052 when she sent this case to the jury. The trial judge in this case has entered summary judgment in favor of Superior not once, but twice, both reversed by the circuit court in its appellate capacity. After the second judgment was reversed, the judge was adamant to push this case to jury trial. Windshield litigation of this nature.
If I may, Mr. Trowell, and I appreciate, I think I've worked with these other judges in a panel before. I think we're all very familiar with the facts, and I'm sure both sides, both judges have read in detail the whole case. My question to you, I think it's very, regardless of all that, the bottom line is we get to review and we get to determine, is there any evidence in this record? We have the whole record before us. And help me out if you can, Mr. Trowell. The key issue here, was it any testimony provided regarding, and this is the contract, the prevailing competitive price to repair or replace the property at the time of a loss? That's the key. Was there any evidence? I'm not talking about Geico's experts saying this is what Geico does, or this is what Geico's, and the cases involving Geico, what they do. I am talking about evidence in the record regarding the prevailing competitive price.
Yes, Your Honor, absolutely. There were 3 witnesses in this trial: Geico's corporate representative, Superior Auto Glass's corporate representative, and Geico's expert witness. The testimony from Geico's corporate representative was that she had reviewed all of the transactions throughout the Tampa Bay area with non-affiliate shops. And those non-affiliate shops are shops that have no obligation to accept the work from Geico. They are independently hired by the insured, and they are bound by the policy contract, Your Honor. And the corporate rep testified at length that based on her review, the vast majority of these vendors in the Tampa Bay area that are non-affiliates that have no obligation to accept the work were billing Geico pursuant to Geico's parameters.
Okay, that's the key. But I guess you just said it, pursuant to Geico's parameters. That's not the issue here, Mr. Trowell. The issue here, what would be the competitive price? The contract that Geico, and I guess let me backtrack. There's a specific contract between Geico and Superior. It's a contract that, it's the Superior because by the assignment of rights, but between the actual policyholder and the insurance, or specific language within that contract. We need to make sure that that specific language is complied with. And so the fact of the testimony, maybe I'm being nuanced and maybe I am wrong, but I thought that the testimony was provided, what Geico was saying, hey, all of you affiliates will be, if you all are be willing to pay what we're willing to pay, is far different from testimony regarding what would be the competitive price. That's my question.
Your Honor, this goes back to the decision in Dick 1, which has controlled the litigation in Hillsborough County for 7 years now. And the Matthew Dick 1 decision was looking at the policy and whether or not it was ambiguous, but it went further when deciding it was not ambiguous. It looked at the policy language and said, the policy language says, this is the prevailing competitive price is the price Geico can secure. Okay, so you have to look at it from Geico's perspective. Matthew Dick 2 further clarified that when it specifically noted that the evidence necessary to show the amount paid by Geico was an amount Geico can secure, when it said evidence that invoices were paid in full by other insurers can only be relevant if the policy language of those insurers is the same as the Geico policies. So it's clear that the transactional information that's necessary to determine the prevailing competitive price are transactions that Geico's involved in, that transactions that Geico is involved in on glass replacements. And the key here is the only transactions Geico's corporate rep and its experts testified and presented to the court were non-affiliate transactions. Superior Auto Glass is a non-affiliate. You said it, Your Honor. They don't have a specific agreement with Geico. They have their agency. They can reject a job. They can see the Geico insurance card and they can say, we know that Geico pays X and we're not going to perform the service for X, so we reject the job. They maintain their agency, which is different from what opposing counsel has alluded to with respect to Geico's relationship with its preferred vendor, Safelite. All of those transactions related to what Geico paid Safelite when Safelite was the repair shop have been excluded. They were excluded on motion in limine. The court got it right. The court got it right on the jury instructions when she said, in fact, me and opposing counsel argued about the jury instruction on prevailing competitive price. And opposing counsel's argument was, these are just insurance transactions because Geico was involved in them, and these aren't open market transactions. Well, Dr. McClave testified that an open market transaction is a transaction between two parties where neither party is obligated to the transaction. That is the only testimony in the record as to what an open market transaction is. I then argued to the trial judge that this insurance transaction was referring to what Geico alone can secure, i.e. when it's hiring Safelite to do the work. And the court said, and I quote, well, I've always thought that as well. And that's why she adopted the jury instruction she did with respect to prevailing competitive price.
Mr. Trowell, let me ask you to pause there. When we're talking about open market transactions, my concern is this, and it flows from the language of the policy written by your insured in the paragraph entitled Limit of Liability. It would appear that in the definitional section, there are two predicates that have to be met in order to get the value in. One, that the price is competitive, and two, that this facility is conveniently located. And as I looked at the testimony of the expert, does he testify that, or she testify that all of these spots that they like are conveniently located and that they're competent?
Yes, Your Honor.
That's the language of your contract, and that's what I was looking for in there. So which one of your witnesses would I go back and read in the transcript that they said we'll examine billing records from these non-competitive places, and we have determined that they are A, by these standards, conveniently located, and that B, they're competent? I didn't see it, but that doesn't mean I missed it because I am only human. And it's a big record and you guys tried it. So I'm hoping that if I missed it, you're going to tell me with almost pinpoint certainty where to go. Well, I shouldn't say it that way, should I? Where to go? But anyway, where to look?
Yes, Your Honor. So I agree with you. With respect to the competence, Geico's corporate rep testified that it relied on the transactions, the non-affiliate transactions, and it set forth two grounds. It says in its ordinary course of business, she testified, Geico's corporate rep testified that in the ordinary course of business, they conduct surveys after a claim is handled. And that survey includes asking their insured if the shop or the vendor of choice performed the service properly or if there were any issues with the repair. She indicated that her review of those surveys did not reflect any negative treatment with respect to these shops that had non-affiliate shops that had performed services on behalf of Geico insureds during this respective time period in the Tampa Bay area. She further testified, Your Honor, that reviewing the claims history, every single transaction that took place in the Tampa Bay area during this time frame, that there was no repetition of a claim. So what happens is a claim number is issued. If a failed repair happens, so if a shop does not perform the repair and that Geico has to send that insured to a new shop, that claim number will follow that claim. And she testified that there's no repetition of those claim numbers for these shops, meaning they don't have a claim number showing up 2 or 3 times because a shop performed a shoddy repair. So she addressed competence in 2 ways. And she was challenged on this in cross-examination before the jury, and there was no evidence or testimony by Linda Rawlinson on behalf of Superior that assessed the competence of any of these shops. Your Honor, there was no counter evidence at all. So that was the evidence, Your Honor, that was submitted with respect to competence and the convenience of location.
I have a question related to that. There was some discussion in the briefs about the burden on that. Is this an affirmative defense, and how established, or is that not established in the case law, that this is an affirmative defense as opposed to the plaintiff's? And this is a limitation on liability. Is the burden with the defendant on a limitation on liability as it is on an exclusion?
Your Honor, we would take the position that the burden of proof has been improperly shifted with respect to the limit of liability. We think there's a litany of case law, and the case law that the appellee relies on, State Farm v. Curran, St. Paul Mercury v. Coucher, all are distinguishable because they actually relate to complete coverage denials. And those complete coverage denials based on an exclusion within the policy, that clearly is the burdens on the insurer with respect to whether or not the—
Can you explain the distinction there? So there's a complete coverage denial and based on an exclusion, and that's been considered and you're maybe conceding without necessarily agreeing that is an affirmative defense. That's not part of the plaintiff's case, but this being if no coverage exclusion is advanced, but instead the coverage is admitted, and we're only talking about a limitation on liability, that on the other hand is not an affirmative defense. Could you explain the distinction?
Yes, Your Honor. I think the best way is, for instance, in the State Farm v. Curran matter, the suit arose out of the denial of UM coverage, and the denial was premised on a coverage exclusion or limitation, but a denial, not a limitation. The denial coverage in its entirety, Your Honor, and that excluded coverage, it's based on the State Farm would have had to prove the ground for the complete denial. In this case, coverage was afforded. There was a reported loss.
Well, no, I understand the distinction between the two. I'm saying, why is one an affirmative defense and the other is not? Logically speaking, why should we put limitation of liability in a different bucket? I know they're different. That's the whole point. So yeah. Why?
Yes, because in a limitation of liability, Your Honor, the coverage has been afforded. Geico has said, here is the payment. We're paying for that. So if the plaintiff is going to say you've breached the contract by failing to pay sufficiently, plaintiff should bear the burden of proving that they're owed additional monies, as opposed to an exclusion. The insurer is the one with the most knowledge as to its policy, how it was written, and the reason for the exclusion. So the insurer should carry the burden with respect to advising the court on why coverage was completely denied. That's my understanding of the distinctions that are made within the case law. And I think if the court examines the Curran case, the Mercury Insurance Coucher case that are relied on by the appellee, those are all distinguishable, and the U.S. liability v. Bove is on point. That Bove case that we cites to a proposition that where coverage is afforded, but there's a dispute as to how much coverage, that burden is on the plaintiff. That is not an affirmative defense, Your Honor. So our position is Matthew Dick 2 told us we carried the burden, so we went into the trial court under that understanding, and we addressed the case in that manner, Your Honor. But in addition to, we raised two defenses. The
Just so
second,
you know, you're at 14. I don't want to, you're
okay,
getting close.
quickly, Your Honor, the other defense was waiver. What we have to recall here is that the jury sided with Geico on two separate and independent defenses, Your Honor. So all they had to do was check yes to one of them, and Geico prevails in this case. In the waiver defense, Geico submitted evidence that Superior knew what Geico was willing to pay. They then accepted the job, they performed the service, and they billed more than that. And the conduct that Geico presented was, one, we admitted and were accepted, exhibits 2 and 13 into the record, were accepted by the court. The clerk stamp represents that they were accepted into evidence, Your Honor. And those were the work orders that Geico transmits to an insured shop of choice to set forth the amount Geico is willing to pay under the policy. Now, in a normal business, a shop has the opportunity to accept that, to reject it, or to counteroffer. Well, the testimony was clear from Superior. It does not negotiate pricing with anyone. Okay, that's clear. There's no dispute of that, which of course flies in the face of Matthew Dick 1, which says the prevailing competitive price cannot be a price that's not negotiated with anyone. Geico extended an offered price. The work order also says that performance is acceptance. Superior performed the job, submitted an invoice for more, as they had done, and the testimony indicates 81 times before this claim.
Is there, so in other words, that seems to be pertinent to a contract, for lack of a better term, to which Superior is privy as a principal or not as an assignee. But can they essentially have accepted under a separate contract and still have the rights as an assignee to higher amount?
Your Honor, that's an interesting question. We have challenged the validity of the assignment of benefits, but not in this appeal. I think in this case, the work order served as an offer. The language in it clearly says performance is acceptance. The testimony by Linda Rawlinson was, and I quote, "We knew what Geico wanted to pay." Okay, so they knew what Geico was going to pay.
You passed 16, so you may want to wrap that up quick.
Non-affiliates, Your Honor. So we think we met the burden under the waiver decision. I will reserve the rest of my time for rebuttal, Your Honors. Thank you.
Thank you, counsel. Mr. Caldevilla, before you start, I'm going to give you my concern. And since I'm going to give you my concern before your time starts, it's going to be, I think, okay. As I understand it, there's a contract of insurance between your customer and Geico. The customer has the right to take the car to the facility for repair that they wish. Counterbalancing, as I thought this through again last night, Geico is only obligated under its terms of a contract to pay a certain amount, regardless of whatever your contractual rights are with your customer, and they define it in the limit of liability. So, proving up your case against Geico, does that mean you have to prove up what Geico had to pay their customer? Because you are standing almost in the shoes of a assignee, and I don't know why the screen says low system resources and blocking your face out, so I'm going to exit. So my concern is you may have a contract for 10. Geico has a policy that, let's say, hypothetically limits it to 6. Is your burden of persuasion to say Geico owes us under the policy 6? And do you meet that by proving what your client owes you or your customer? I hope I'm somewhat articulate before your clock starts running, but that's my concern, because I'm concerned there's kind of two burdens of proof. One as plaintiff, and one in affirmative defense would come in and say, I admit that we're liable, but we avoid it by saying this is the correct amount. So I hope I've phrased it in a manner that allows it's conducive for you to respond. And if I haven't, feel free to tell me, because I've been told that before and I will take no offense. Now we'll start your clock.
May it please the court. Good morning, Your Honors. I'm Dave Caldevilla, Behind me here in my office, off the screen is my co-counsel, Tom Elliott. We represent Superior. So let me get right to Judge Casanueva's question, which is actually a little bit longer version of Judge Atkinson's question, is whose burden of proof is this limit of liability? In the case law, well, first of all, let me just say that Geico at trial conceded that proving the limit of liability was its burden, conceded that issue at trial. They also have not raised it as an issue on appeal. Hasn't been raised as an issue on appeal. So with that said, who has the burden? Geico has the burden. The insured's burden, and we stand in the shoes of the insured, is to only prove that we have a covered loss, which Geico conceded at trial. Geico conceded that we had a covered loss, and they then conceded that it was their burden basically to prove the whole case, which was that they complied with their limit of liability and that we waived the right to recover the prevailing competitive price. Now, that I believe answers Judge Atkinson's question. The case law is crystal clear. I've cited probably half a dozen cases, but let me just say this. It's not just applicable to insurance. Anytime a defendant is relying on a contract provision or a statute to limit the amount of damages that the plaintiff can recover, that limitation is the defendant's burden. And Judge Casanova, I will point you to one of my least favorite cases of all time that you wrote, which is the Gottlieb case versus Alps, where you ruled against me. But that was a case where I believe there was either a contractual limit of liability or statutory limit of liability.
UCC code and all that stuff and
Yes.
documents being faxed. Yes, I remember that.
You
And
remember
there's a
that case?
passage in there about affirmative defenses not being pled and waived.
I painfully try to forget that case as much as I can, but I do remember that that was an example of a case where it's the defendant's burden to prove that.
Page 5.
And it's everywhere. All
I
the
read it
cases-
last night.
Right. So the only case that says different is this third DCA case that Geico likes to cite, which is called the Bove case, which is 46 years old, cites no authority, is inconsistent with the third DCA's subsequent case law, which I believe is the Herrera case. This court in Mejia versus Citizens Insurance, everybody says it's the defendant's burden. So then to answer the next part of your question, Judge Casanueva, which is, all right, do we accept the limit of liability? Yes. We agree that if we charged $1,000 for this windshield, or $10,000, let's say, for this windshield, and Geico came in and said, look, Acme Windshield Shop has been in business for 20 years. They're competent. They're right down the street from Mr. Dick. They had Ford Escape windshields available at their fingertips that they could pick it up in 2 hours, and were ready, willing, and able on February 15th to accept $379 for that windshield, then we'd be stuck with paying accepting $379. Geico filed a witness list with 113 witnesses saying they were going to call 113 windshield shops because they knew that it was their burden to prove that any shop that they identified who would accept $379 for this windshield, they had to be competent and they had to be conveniently located. And the only way that they could do that was to call in all these windshield shops. And they wanted
In
to
this case,
continue.
the windshield shop in question is in Newport Richey, right?
It's a that's where the brick and mortar store is. I believe that's the case, Judge.
Okay, I was
But
looking
they
at the
come
bill,
out-
I assume perhaps wrongly, that's where the repair location was too.
I'm not positive. I don't want to
Okay.
misstate the record, but I
No,
think
that's fine. I appreciate for that clarification.
Right. So, but the bottom line is, Geico understood what its burden was. They said we gotta call in all these windshield shops to testify that they were competent and that they were conveniently located, that they were really ready, willing, and able to accept $379 for the. So let's have a continuance, because there's no way we can have this jury trial with that many witnesses. And Judge Ober said, no, we're not going to continue this case, but I will give you more time. I'll come in late. We'll go to weekends. If you want to call some of these witnesses electronically, I'll bend over backwards to make that happen for you, Geico. So what happens when we get to trial? There's not a single windshield shop would come in and testify, or they wouldn't call a windshield shop to testify. They said they made a strategic trial decision not to call any of them. So what did they rely on instead? kind of gets to Judge Casanueva's other question on that he was asking Mr. Trowell. You said that two of the requirements that had to be proven were that the windshield shops were competent and that they were conveniently located, right? And you said, where is it? Where are you going to point me to, Mr. Trowell, where I can find that a witness testified that this other shop who was going to take 379 was competent and conveniently located? So Mr. Trowell says, oh, well, that's in the record everywhere. No, it's not. It's not in the record. In fact, he pointed to Miss Eberling. First of all, he pointed to Miss Eberling, which is Geico's corporate rep. So let me direct you to page 6696 of the record, which is the trial transcript, 6696, where she testified that Geico does nothing to determine the competency of any other windshield shop. They don't do that. So then he says, well, she testified that there were surveys and she looked at the surveys and she concluded that everyone is competent. Well, she testified that there were surveys. She did testify that there were surveys. She didn't say what the surveys were, what they asked, what the results of the survey was, that Acme Windshield Shop and all these other windshield shops, the survey says they're competent. She couldn't testify to that. It's not true. And it's not even, it's not admissible. It's hearsay, violates the best evidence rule. Never got to it other than vaguely saying, oh, there's some surveys out there. Then he says, well, she also said that she could tell if a windshield shop was competent if there was no repetition. In other words, if the claims history shows that a customer had to go back a few times to get the windshield fixed, that would mean that shop's not competent, but all the other shops that don't have repetition are competent. She didn't, well, first of all, the claims history itself, inadmissible, was not allowed to be in evidence. So she was vaguely referring to that, but she didn't, again, did not take it to the next step, didn't say, and I looked at the claims history and I found these 110 windshield shops that never had a repeat repetition, a customer coming back for a warranty repair or anything like that. And so therefore those shops were competent. Never did that, never went to that step, only said that, well, you know, you might be able to see that if there was some repetition. But the claims history is not in evidence. She didn't identify any competent shop. Not one competent shop did they identify.
But it is evidence. It couldn't. It's
evidence, but it's
circumstantial evidence from which a reasonable inference could be drawn that the shops from whom they secured prices were competent. So shouldn't it have been left for the jury to determine?
No, there's no evidence of any competence. She testified, Judge, that Geico does not check the competence. Their expert testified he did nothing to determine the competence. The way to prove up the competence is the way Geico said they were going to do it, was to be calling windshield shops up and as witnesses and saying,
asking them if they're competent. Are you competent? Was that they were supposed to do?
They could say, how many years have you been in service? How many windshield have you changed? Are you licensed? Same thing that they make our client do. Yes, they could have asked those questions. I didn't write that policy, Judge Atkinson. Geico wrote it. Geico says that a prevailing competitive price is the price that Geico can secure from a competent and conveniently located windshield shop. I didn't write that. Geico wrote it. What's wrong with making Geico come forward and say, this windshield shop right here, Acme Windshield Shop, was competent, and here's why. And they would have accepted $379 to replace Mr. Dick's windshield on his 2015 Ford Escape on February 15th. Because there aren't any windshield shops that would have done that. None. They proved that. In fact, Judge Kuzan, you asked, is there any evidence in the record of the prevailing competitive price at the time of the loss? And Mr. Trial says, yes, there is evidence. Well, the only evidence of the prevailing competitive price, which is undisputed, it is in this record, is the 3 invoices from Auto Glass America that Geico presented in Dick 1 and Dick 2. 3 invoices from Auto Glass America, all involving Ford Escape windshield replacements in the same time frame as my client replaced Mr. Dick's windshield. All right. Geico was asked, tell us other shops that will replace this windshield at the prevailing competitive price. By the way, that's what their policy says, that if you go to the limitation of liability provision, it says what the prevailing price is. In the very next sentence, and this is on page 7412 of the record, it says, at your request, we will identify a repair facility that will perform the repairs or replacement at the prevailing competitive price. So Geico says they can do that. They say they'll tell their insured. Why can't they come in and tell the jury that? Why didn't they come in and tell the jury, hey, we've identified these shops? They didn't. There's 3 invoices that they presented in the first phase of this case that resulted in summary judgment against Geico. We asked them, who's the prevailing, who's the windshield shop that would have accepted the prevailing competitive price? They say, okay, here's 3 invoices from Auto Glass America. They would have, they're the prevailing competitive price. That's their answer. Look at their interrogatory answers and their response to the.
Let me ask you this. So they secured that price.
Of over $800, Judge Atkinson.
Now, what about these other ones that were closer in your brief? You mentioned, maybe I'm confusing 2 different pieces of evidence.
Right.
But the ones that were much closer in price, 385.14, the 385.15, the 404.84.
All over $379. So Geico testifies that they
Right, so-
never pay more than.
Yeah,
the
but
prevailing competitive
can you
price.
just pause for a second? Because you need to clear it up for me if I misunderstand the record.
Right.
Were those the Auto Glass America invoices?
No. So Geico's claim history, and Judge Kazam knows this because she was on the Mercado case where Geico was found to be tampering with that evidence and excluding transactions, et cetera. It's filled with inaccurate information, but there's 3 Auto Glass America claims that were all over $818. Then there's 4 other claims that were discussed at trial that were more than $379, which were in the $385 to $400 and something range, Judge Atkinson. So let's be clear. The evidence, the undisputed evidence, according to Geico, was that Auto Glass America had the prevailing competitive price. All 3 of the invoices that Geico produced were more than $818. All 3 of them. Then we get to trial, and the claims history has 28,000 transactions in it. Okay, 125 page, over 200 pages with about 100 transactions each. You got to get a magnifying glass to look through it. But I can tell you for certain that if you search for those Auto Glass America invoices that Geico said were the prevailing competitive price, you won't find them. They're gone. They disappeared. Kind of like the Mercado case, Judge Kazam.
Well, just can you explain? I follow that, but can you explain the 380 the 2 claims for 385.14, 385.15, and the 404.84? Those were the claims that were found that were still there, and there was a trial, right?
Right. So they're still there, and their expert relied on this claims history. And note, he testified, well, Geico pays the prevailing competitive price. That's his opinion. Doesn't say that 379 is the prevailing competitive price. Doesn't say that 818 exceeds the prevailing competitive price. So in cross-examination, we say, well, your opinion was that Geico always pays the prevailing competitive price. What about these 4 claims right here, where Geico paid more than $379 for a 2015 Ford Escape? How can 379 be the prevailing competitive price when Geico paid more for those 4 transactions? It can't be.
Yeah,
And
but one of them is, a couple of them are only $5 more.
Well, that's $5 more than they pay us, Judge.
Okay, so you want $5?
Judge,
Is that what your claim is for?
what you want is the prevailing competitive price.
So my question, I jest, but my question is this: is if and this goes to perhaps the way the parties and the judge and the prior 2 panels of the circuit court level have interpreted the provision at issue, aren't those prices that Geico could secure? I mean, they could secure because they adduced presumably uncontradicted evidence that they did secure those prices. So they secured prices that were as close as $5 more than the price charged to Superior, right?
Yeah, that's what their claims history.
Isn't that what the provision says? It says the price we can secure, leaving aside the competent and conveniently located, which you guys have ably argued both sides. But didn't they secure a $385.14 price?
According to the inadmissible claims history spreadsheet, which was not in evidence, Geico claims that they secured those prices, each of which exceeded $379.
Wasn't she impeached with that evidence?
The expert was, and
Okay.
it shows that his opinion is totally invalid. How can it satisfy the Daubert test? How can it satisfy the rules of evidence under 90.702, 704, and 705 when the expert opinion is contradicted by the data he purportedly relies upon? And that claims history.
So wait a minute, so that
Let me pause here just so everybody knows where it's 16.
Oh, okay, so to impeach, and the expert was impeached with a claim that was $5, which is less than 1%, more than what was charged, and that cast doubt as to the expert's testimony, to the extent that we should not, the judge should not consider it or not allow the jury to consider it.
His testimony was inadmissible, Judge Atkinson. And yes, if you go to a restaurant and you get a bill for $379 and you pay $375, I got to guarantee you, you got a problem. People have to pay the correct amount that they promised to pay. Geico promised to pay the prevailing competitive price, which is the price that they can secure from a competent, conveniently located facility, not the lowest price, the price they can secure. The plain text of that policy, which the Florida Supreme Court says is what we have to rely upon, and what the Federalist Society says we have to rely upon, does not say that the lowest price is what we is the.
Let me ask you this.
prevailing
That's an interesting argument, because I think you accused, or maybe credibly, the other side of agreeing that it's not the lowest price. But let me give you the hypothetical. Let's say it's a much simpler case, and there were just all there was in evidence was indisputable invoices that were admissible and authenticated and all that, and it was 350, 370, and 400, and the plaintiff assignee had been paid 350. Just because it's the lowest price doesn't change the fact that it was a price that was secured by Geico, correct? So why would Geico choose to charge to pay the highest price it can secure? Isn't effectively this provision allowing Geico to pay when it pays a claim the lowest price it could secure?
Okay, so am I going to have any time left, Judge Casanueva?
Yes.
Okay, so to answer your question, Judge Atkinson, the answer to that is no, and here's why. Geico's corporate rep testified that Geico never pays more than the prevailing competitive price, which is based on these parameters, by the way, that aren't in the policy until 2018, which they're trying to retroactively apply to my client. But let's go with their testimony. They never pay more than the prevailing competitive price. They paid my client $379 for Ford Escape windshield replacement. They paid Auto Glass America over $818 for 3 windshields. So if Geico never pays less than the prevailing competitive price, how can $379 be the prevailing competitive price? If they pay $404 to someone, how can $379 be the prevailing competitive price when their testimony is that they never pay more than the prevailing competitive price? Because they're playing games, Judge Atkinson, that's why. Because these set of parameters that they're applying has nothing to do with the limit of liability provision, the test that's in there, which is the prevailing competitive price is the price that we can secure from a competent and conveniently located facility, not 50% off of NAGs, $40 an hour. That is not in the policy, and the policy says you can't waive the provisions of the policy. Can't be waived, can't be modified until you adopt an endorsement. They adopted an endorsement in 2018. This case is 2015. They cannot retroactively apply that policy language to us. If I have any time left, Judge Castro and Judge Atkinson, did I answer your question?
Yes, thanks.
Thank you.
To apply that retroactively would perhaps violate a constitutional provision about the impairment of a contract?
Well, it's not a constitutional, and it's not a statute, so I don't know if that applies, but I think it's pretty clear that you can't
Here's
apply
something
a
about impairment of
2018.
contracts. You're right, it's not a statute. You're well taken,
All right,
well taken.
thank you, Your
Okay,
Honor.
let me go back just so that everybody knows what the grounds are going to be. Since we've had questions right about the escape time at 16 minutes. How to phrase it? By the power invested in me in the center chair. That's how I guess I'm going to rely upon the inherent authority. Everybody's going to get their 4 minutes. And off we go. So, Mr. Trowell, you'll have your 4. No
And Judge
subtractions.
Casanova- And Judge
Yes, ma'am. Yes,
Casanova,
Counsel. Yes, Judge.
I concur in that decision, okay?
You know, sometimes you are correct by sheer numbers.
All right.
I thank you. So, Mr. Trowell, did I pronounce that right? I'm kind of getting my glasses
Your Honor,
clogged up
Trowell.
here. Thank you. We will give you your full allocation of 4. And as I said earlier, the floor is once again yours.
Thank you, Your Honor. I'll start right back where the vast majority of Appellee's argument is, and that is a reweighing of the evidence. Appellees, we had 3 witnesses and 3 full days of trial. To say that the thoroughness of the direct examinations and the cross examinations were anything but shotgun approach, in depth, in detail on everything, to say that Appellee didn't challenge and present to the jury every minute potential issue with Geico's corporate representatives' testimony about the competency and the convenience of location would be to misstate the record. They questioned the Geico's corporate rep with respect to the surveys. They questioned the Geico's corporate rep with respect to the duplication of claims and whether or not that she could assess the competence. Yes, Geico testified that they don't do an individual assessment of each shop within their normal course of business practice, but they were able to deduce from these surveys, as well as looking at the transactional history, to see that these shops, these non-affiliate shops that performed repairs, did not have repairs that had to be redone, therefore pointing to their competency. And all of these issues raised by Appellee were raised on cross-examination and impeachment. These were all non-affiliate shops within the Tampa Bay area. Most of these shops, as testified, have mobile capabilities, which is why the Appellee was unable to address whether or not this replacement took place at the brick and mortar shop or if it took place at some other location like Matthew Dick's work or residence, Your Honor. Most of these shops. And that was the testimony that the jury heard, and that was the testimony that was cross-examined, Your Honor. Secondly, the focus by Appellee on the witnesses that Geico strategically told not to call is misplaced. And in fact, the trial court relies on that as well in her order when she states, when she focuses on the fact that the Geico didn't call shop witnesses. Again, this fact that Geico didn't call these witnesses was pointed out to the jury. The jury had that before them. None of the evidence presented are addressed by the trial court relates to no evidence. It's a complete reweighing of the credibility, Your Honor.
And if I may, Mr. Trowell, I guess that goes back to my initial question of you. In reading the entire transcript, we have to make a determination whether there's any evidence in the record that would support exactly what you said. And so I think right now, in going back and determining as to who testified to what, and I think both Judge Casanova and Judge Atkinson have already expressed, some of their views and concerns about this. And you know what? And you only have a few minutes left. I'm going to withdraw my question to have you have an opportunity to address you and Judge Mr. Caldevilla regarding.
Sure.
I guess I'm having real concerns because I read the entire transcript to determine whether or not there's any evidence in the record supporting the fact that there is a prevailing competitive price that it's within, places that are competent. I'm struggling with that, Mr. Trowell, and I just wanted to let you know.
Well, the jury heard that evidence. I've told the court what the evidence was. Our brief set forth what the evidence was with respect to competence and convenience. There's no dispute that that was the evidence and the evidence that the jury could have considered. With respect to prevailing competitive price, Your Honor, we have the Geico's corporate rep said of all of the non-affiliate shops in the Tampa Bay area, this was the testimony, and this is the testimony that was challenged on cross-examination. The vast majority of them bill Geico pursuant to its parameters. This is what Geico can secure. So these shops are selected by the respective insureds, and they are billing Geico pursuant to Geico's parameters. Let there be no mistake. Superior has the same parameters. We're trying to cloud this in mystery. Superior uses 100% of nags, $85 per hour, and $50 or something for each adhesive kits. These components are the same between Geico and Superior. Geico just assigns a different value and was able to say, we are securing that from the vast majority of shops. Geico's expert confirmed that. Your Honor, these Auto Glass America invoices, Matthew Dick 2 addressed that, and I think I need to point it out when they said the evidence of Geico's payment of these additional amounts related to invoices that were in dispute. AGA had 11,000 cases pending with Geico, and Geico paid those invoices in settlement, Your Honor. So I think it's a complete misnomer. But those invoices,
Hold on, Mr. Trowell, you need to wrap up. We're past the 4, and we'll make sure to bring this to a conclusion.
Sure.
And not that we're just going to let everybody guide. So you're
Sure.
at 5 now, but go ahead, wrap
Okay.
up, make your quick argument out, so we can move on to Mr. Caldeville.
Sure. Those invoices were presented to the jury. The jury had them to consider. We submit that Geico requests that this court reverse the trial court's judgment, remand with instruction to enter final judgment consistent with the jury verdict. Geico also requests that Superior's cross appeal be denied.
Thank you. Made the machine work. Mr. Caldeville, you too have 5.5.
Thank you, Your Honor. May it please the court. So I just want to mention something that Judge Kuzan just said.
I've lost your voice, Mr. Caldeville.
Can you hear me
I
now?
don't have your sound.
Can you hear me?
I still don't have your sound.
I
Am I the
could-
only one?
I have
believe-
him, Judge
I
Cassidy.
don't have
I
Nellie's
could hear.
Kazam sound.
I
What's
could
going on
hear,
here?
I could hear Mr. Caldevilla.
I don't hear anybody.
So I guess I request the clerk to check in with Judge Casanueva.
Just stand by and we'll have IT check it. Please stand by.
Thank you.
Hold on, we're on.
Can someone just ask a question or talk so I can make sure the judge has my.
Test.
Can you hear me, Judge Casanueva? Okay.
Testing.
Mr. Caldevilla, why don't you say something, Mr. Trowell, I think you're done with your argument. Mr. Caldevilla, say something, see if Judge Casanueva could hear you.
Please don't let Mr. Trial say anything else.
I heard.
Okay, all right.
And we'll see.
All right. Are you ready?
Yes, sir.
May it please the court. Thank you for this last bit of time. Let me first hone into something Judge Kuzan mentioned, that in order for this court to reverse, you got to find that there was competent, substantial evidence to support Geico's affirmative defenses. Competent. And And there is none. I'm telling you, when you go ahead and read that transcript and see what the witnesses testified, what was excluded, and that leads us to the cross appeal. If this court affirms the final judgment, then I submit that the issues I'm raising on cross appeal are moot or harmless error, I guess, at that point, because you're affirming. But if by any stretch you find that the judgment in this case has to be reversed, then I'm going back to square one, and that is that Geico presented to us. We didn't come forward with this evidence. Geico presented to us 3 invoices from America, Auto Glass America, saying that this shop, these invoices are the prevailing competitive price that we can secure. They said that. We didn't say it. They said it. They came forward with it, and we said, okay, well, look at the price. That's more than $818. We win. That's it. That was appealed. And instead of mentioning that undisputed evidence, the only evidence that goes right to the heart of their only defense that they were raising at that time, instead of affirming, they disregarded that, didn't mention that, and came up with this interpretation of the policy language where they say this policy language is clear and unambiguous, but no one would expect it to be given the literal meaning. That's kind of contrary to all rules of contract interpretation that we're being led by the Florida Supreme Court and the Justice Scalia textbook that everybody knows and loves, that we've got to comply with the plain language and not read things into the contracts that aren't there. So we should have won the summary judgment. That should be reinstated. The second summary judgment, after they adopted all these standards, explain what that one sentence means in 9 pages. We go back down and we present more evidence. We present the affidavit of the Auto Glass America shop owner who submitted those 3 Ford Escort invoices to Geico. Again, undisputed evidence that Geico paid more than $818 for a Ford Escort windshield. The evidence that they produced. We're back. We won summary judgment again, and they say, oh no, there's a disputed issue of fact here, and all this evidence is inadmissible, which, by the way, those are issues that Geico didn't even raise. Did not raise on appeal. This was sua sponte analysis by the circuit court acting in its appellate capacity. The thing that they did right in Dic 2 was to recognize that this is really Geico's burden. So I'm not asking you to reverse that part of Dic 2 because they got that right based on the Florida Supreme Court decision of Kern and all the other dozens of cases on this issue. But the damages that were awarded under the second summary judgment were absolutely correct and should be reinstated. If I lose on that, we deserve a new trial. There was gobs of inadmissible evidence presented in this case, not the least of which was Dr. McClave. And we objected up and down. We filed a Daubert motion. I think the judge felt like she was going to let it in to see what the jury would do with it. But at the end of the day, the judge recognized that there was no evidence of competence, no evidence of a competitive market, no evidence of waiver, none. And so she had to grant the JNOV. But if for some reason that gets unraveled, we need a new trial with only admissible evidence. Claims history can't come in. Dr. McClave's testimony cannot come in, and the jury needs to be properly instructed on this standard, whatever y'all think it might be. But when we went to trial, the standard was that there can only be evidence of non-insurance transactions. That was established by Dic. So I'm sure I'm close to being out of my time. So before Judge Casanueva interrupts me, I want to ask you to affirm, but if you don't, please reinstate the summary judgments. And if you don't do that, please give us a new trial. Thank you so much for your time. And that'll be it for me today.
Thank you, and thank you both for going with us through all the electronics that we've been having today. It has been requested that the court take a brief continuance